this case, it's all settled and done. We're just waiting on a couple more reductions. And so,
Right. I think Mr. Almanzan mentioned that they need some written confirmation on some amounts with lien holders. I reset it for 60 days. Please update your information, I guess, for the e-filing and all of those things so you get notice. We'll see you
yes,
in
Your Honor.
60 days. Thank you very much.
Thank you. May I be excused?
Yes, sir. Have a good day.
You too. Thank you, Judge.
All right. Good morning. This is Judge Alyssa Perez presiding over the 210th District Court Civil Docket for March 11, 2026. All matters being heard today are being heard in accordance with all directives regarding remote proceedings. Where are we headed next, Mr. Nanez?
Judge, on page 1, we've got Mr. Thomas here for the case. Do you want me to call it?
Page 1, which case?
It's gonna be 2024 DCV 3097 Joseph
Okay.
Vishhawe versus Nara Orozco Gomez.
May I have announcements, please?
Yes, Your Honor. Good morning. Attorney Steve Thomas for the plaintiff.
So is anyone here on behalf of Laura Orozco Gomez? Looks like it's Mr. McLean, but we were just supposed to enter our scheduling order and we haven't received it yet, Mr. Thomas. Is there a holdup?
Yes, right. So I was looking through because the coordinator asked. I see that we attempted to file it, but got rejected previously, Your Honor. That was back. I apologize because that was back last year. We even tried to file it, the agreed scheduling order, but I'm just not too sure because our original scheduling order, we had a trial date for April 17th actually, and a pretrial for next week. So I'm not too sure if those dates are still even available potentially.
No. We've had a hearing since you're talking. We had an entry scheduling order hearing and a DCO back in 2025, but we have since, looks like we had a final status conference on February 11th, and let me see, there's an order setting jury trial. So I have to think we discussed a scheduling order. Today was the entry of that scheduling order. So
Yes, sir. I apologize.
who was here at the last hearing? I don't believe it was you.
No, it was one of my coworkers. I can look and see who that was, Your Honor. Give me one moment here.
I'm less concerned about who was here than I am about getting a scheduling order. Please, I'll give you a week reset, review, and check and see where that scheduling order is. Turn it into the court if it's agreed to, and we won't have to have that hearing, and we'll get your interim settings set. Right now, you do have your jury trial in March of 2027. So that tells me we discussed a trial date, and we're just pending the entry of the DCO. So we'll have a week for an entry hearing, Marissa. Let's do it at the 3 p.m. slot, like the normal slot, and track it down. Find out. If not, we'll see you at 3 p.m. next week.
Yes, understood, Your Honor. Thank you. Maybe excuse.
You may have a good day.
Thank you, Your Honor.
Next?
Judge, on page 2, calling cause number 2025 DCV 1715. Announcements, please.
Good morning. Reagan Bibb here on behalf of defendant Antonio Salazar Jr.
Good morning. Linda Samples on behalf of defendant Progressive.
Good morning, Judge. Stephen Lucy on behalf of the plaintiff, Linda Mendoza.
Are we missing anyone? Let me pull this case up. We're only set for a scheduling status conference, so I'm going to ask you my usual question. Are you all ready for a trial date?
Your Honor, at this point, I'm not sure if it was this status hearing or the other status hearing, but there's 2 cause numbers in this case. There's another one in the 171st where Linda Mendoza was sued, so she's listed as a defendant in that one.
Was this case supposed to be consolidated or transferred to the 171st?
E403. Yes, Your Honor, it was supposed to be transferred to the 171st. So what happened was that we're coordinating all these depositions. We've had 2 depositions so far, and I guess it fell on deaf ears because I was asking if they would like to draft the motion to consolidate. However, they have not, so I'm going to take it upon myself to draft the motion to consolidate so we could go to the 171st since they did file first, Your Honor.
Yeah, I think I remember that discussion, at least in terms of a timetable being the case. So,
So at this
maybe-
point, Your Honor, I would propose the idea of getting a 60-day reset of a status hearing because we do have a trial date in that other court.
Mhm.
And so to see if we can get that order granting the consolidation.
So I think 60 days, well, does anybody have any input? Number one, my first thought is 60 days is like way too long. Can we just do that in 30 days? I mean, it's basically what was pending since February 18th, right?
Correct.
Okay.
Okay. Yes, I could get that filed and send an order today, Your Honor.
All right, we'll come back in 30 days, but I don't want to cut out Ms. Samples or Mr. Bibb. Do you all have anything for the court?
No, Your Honor.
No, Your Honor, I'm covering this hearing for Jose Vega, and to Mr. Lucy's point about the motion to consolidate, it was communicated to me that Mr. Vega is working on that motion.
Okay.
Oh, okay.
Okay, so figure it out, 30 days, and then we'll see where we are. It'll just be another scheduling status conference here, but I feel like this is a repeat, so let's try and take care of it, please. Thank you. When's your trial date in the 171st?
It is on August 3rd, 2026, Your Honor.
Okay, all right, we'll do 30 days. If there's nothing else, you all are excused.
Thank you, Judge.
Thank you, Judge.
Take care. Who's next?
Judge, back on page 1,
Mhm.
bottom of the page, calling cause number 2025 DCV 3479, Venegas Engineering Management et al. Versus Construction LLC, NKA VEMEC LLC. Announcements, please.
Your Honor, it's Susan Forbes, and I have non-suited this case. I apologize
Yes,
for
there it is.
any confusion.
No. You know, we've had quite a few emails, so it might have gotten past us, but I see that the order for non-suit was actually filed yesterday. So it's been signed, everything's been taken care of.
Well, thank you, Judge. I'm sorry for the confusion.
No worries, no worries. Thank you for your time. Who else was here on that one? Anyone? I don't see Mr. Zimprich. All right.
I don't
Take
see
care.
Mr. Zimbrich either. Thank you very
Take care,
much, Your
Ms.
Honor. Have a
Forbes.
good day.
Bye-bye. Who's next?
Judge, moving to page 3,
Mhm.
calling cause number 2025 DCV 1374, Sosalva
No, we
Alvarado.
already took care of that case.
I'm sorry, Judge, I missed that one.
And was that the motion to consolidate with the kind lady that was on here a minute ago, Miss Cousins, Grace Cousins?
No, this is the motion to compel. Was that Miss Cousins? I didn't write down her name.
Yes, Your Honor, it was Miss Cousins, and
Yes.
it's set for 30 days scheduling status conference because they agreed to all the 4 plaintiffs' motions to compel.
Okay,
And
so
there was a motion to consolidate that I was here for on that matter as well.
do you show a motion to consolidate, Ms. Nieto? Being set today?
No, the only ones that were set were those 4. Pretty sure it was just an email asking for additional motions to be heard, but let me double check.
My apologies.
No worries, Mr. Haas. Let me go back and look at this because what
I
I
didn't know
show as being set today were the 4 motions to compel. And then let me just go through some of the entries again. You're saying there's a motion to consolidate that was pending hearing? Yes?
That is what I was told, Your Honor.
Who told you that, Mr. Haas?
I had a link for this. I apologize.
The order to consolidate, and we're talking about 1374, was the one back in January, but I don't show that was set for hearing.
Okay. Thank you, Your Honor. My apologies.
Okay, no, that's okay. That's okay. Make sure we're all on the same page.
No, Your Honor, I don't have any email asking for a motion to consolidate. The
Okay.
last email I have is from this morning, from Woodsmith, Henning, and Berman. Not sure who they represent. Defendant Los Paisanos, motion to compel discovery, but I don't know if That's just this morning at 8:59 a.m.
I think that's what Ms. Cousins was here on and was resolved, because she has all those.
Yeah.
Yes, that's correct. May I be excused, Your Honor?
Okay, we'll be back in 30 days on a scheduling status conference, okay?
I apologize for wasting the court's time.
No, no worries. Thank you. Who's
Thank you.
next?
Judge, on page 2, I see the case is marked as being dismissed on 2024 DCV 3190.
Okay. Is anyone here on that case? No? All right, who's next?
Moving to page 3, Judge.
Mhm.
Calling cause number 2021 DCV 3028, Rosa Maria Salcedo de Alonso et al. Versus Fifth Floor Freight LLC et al. Announcements, please.
This is Benjamin Kemble, movement, present for F&F Construction, Inc.
Eric Lundin for Vordo LLC and Fifth Floor Freight.
Ethan Evans of Claudia Guzman on behalf of the estate of Gilberto Aresti.
Okay, give me a second. Give me a second, because you all are so many and there's so many new faces now. So I am, even though we don't see each other as often as it seemed like we did at the beginning. Now I know Mr. Evans, that's a new face.
Yes, Your Honor. I'm filling in for Pedro Leyva.
Okay, okay. All right, Ms. Dominguez, Mr. Forbes, but keep announcing. I'm sorry, I just wanted to make sure, because at first I thought there weren't enough boxes for this case. But now I'm seeing more faces. Let's keep going.
Judge, my name is Brad Bartlett. I'm here for Detmar,
Gotcha.
and Sean Page is the attorney in charge.
Judge, this is Leticia Dominguez. I am the dependent administrator of the Uresti estate.
Allie Shackle on behalf of Vorto Operations LLC.
Brian Zube on behalf of the plaintiffs, the family of Alonso Montalongo.
Is that everyone? Okay, bear with me. So we're here on Mr. Kimball's motion for summary judgment. Just bear with me 1 second. Mr. Kimball, you may proceed. The system is really, really slow, so.
Understood, Your Honor. Thank you.
It's loading.
Yeah, and if you need to stop me at any point, no problem.
Yes, sir.
So, Your Honor, this case has been on file since August 2021. It's set for trial August this year, so that'll be the 5th anniversary of this case. And as you noted, people are coming and going. I guess this is one of the longer ones. My client, F&F Construction, was brought into the case in July of 2023. So in a couple months, we'll have been in the case for 2 years. We're a construction company that was doing construction on the road, and it's a long stretch of road where this accident happened. There wasn't any active construction going on at the time of this accident, which was in the early morning hours, around 4 a.m. And it was not in an active construction zone, but there was some lane closure that had been done because the entire stretch of highway had been narrowed for this long bit of work that was going on. We were brought into the case, like I said, in 2023. We answered discovery not long after we were brought into the case, where we disclosed the names of the individuals from F&F Construction who were working on the project or knew about the project. And we also produced the traffic control plan. This was a text dot contract, so work for the state. The state creates the plans, and my client executes the plans, and they're not to deviate from the plans. The state comes up with everything. The engineer for the state of Texas comes up with the lane closures and what signage and all of that stuff, and my client just does it and is paid to do that. So we produced the entire traffic control plan, which included this stretch of road. And as I noted in the reply that we filed, that was produced 843 days ago. With that and the names of the individuals who worked on this particular project. So we're 5 months away from trial. We filed our no evidence motion for summary judgment against both sets of plaintiffs, the Guzman plaintiffs and the Alonso plaintiffs, or Miss Guzman, actually. Miss Guzman did not respond to the no evidence summary judgment. So just as a preliminary matter, when a no evidence motion for summary judgment requires a response, if there's no response, it must be granted. And so we've submitted this morning a proposed order dismissing the Guzman claims against my client for the motion for no evidence summary judgment. The Alonso plaintiffs filed a response to the no evidence summary judgment, and we have attacked the evidence and the arguments therein in the reply that we filed within 7 days of the response that was filed. Pretty much everything I can tell you today is set forth succinctly in that reply, but I'll just hit the quick points so as not to waste the court's time. Basically, it boils down to they're claiming the fact issue that they are able to raise comes from a report from a Mr. John Smith. This report is over 6 months old. It's actually about 7 months old. We've never seen it before until this summary judgment response. It's not sworn. It looks like, it's an expert report, but as of right now, as far as summary judgment evidence is concerned, it's just a letter from Mr. Smith to the lawyers for the Alonsos. It did not include a CV. It did not include a case list. It didn't include anything that would indicate the qualifications of Mr. Smith. So the first thing we've objected to is this even being used as competent summary judgment evidence. As we said before, summary judgment evidence has to take the form of discovery answers or affidavits, or something that you would use at trial. And if an expert was going to testify at trial, it would need to be under oath. It would also need to pass Rule 702 requirements for expert qualifications. That's not even here. We don't even know who this John Smith is on the face of the evidence that was submitted. This could be anybody. So they're not qualified to make any statements as an expert. The report itself is hearsay, which can't be used as summary judgment evidence. It's not attested to or sworn. So for multiple reasons, it basically cannot be used as summary judgment evidence. We've asked that it be stricken.
Mr. Kimball, let me stop you right there. Mr. Zubay, are you responding to this? And if you'll unmute, please, because I just want to hear your response on the objection to the summary judgment evidence.
Yes, Your Honor. As a general matter, the expert qualification issues and the summary judgment evidence issue are kind of separate analyses. I would just point out that, the idea that he isn't identified at all on the letter is not really correct. He's identified by the firm that he's at, and his signature block contains a number of qualifications, degrees, graduate degrees that he's received, such as masters in engineering. He's a licensed engineer. And the fact that he hasn't, that the report has not been disclosed before speaks only to kind of the same grounds as our motion for continuance. I think that the report contains his preliminary conclusions and is competent summary judgment evidence for purposes of determining whether there's a mere scintilla of evidence. I would also point out that there are facts identified in the report that are independently corroborated by other summary judgment evidence, and that it's not solely the report that denying the motion for summary judgment would depend on. I'll just leave it there for now so that Mr. Kimball can.
Yes, thank you.
Thanks, Brian. You can put any number of letters after someone's name. That's not qualifications. That's just letters after a name without a CV, without a case list, without a list of publications even, or even an affidavit to the court as to what his qualifications are, it doesn't meet 702 standards. And I've attached case. I mean, I've cited to case law that states you have to have the expert be qualified to respond to a summary judgment. Now, there is other evidence that he's claiming, is corroborated. Those bits of evidence are referred to in the letter from Mr. Smith. Those bits of evidence include or consist of some investigative reports, what appears to be from law enforcement personnel, and and photographs. Summary judgment evidence is also, and that's in the plain language of the rule, has to be authenticated. Not a single photograph that's been attached has been authenticated as to where it was taken, when it was taken, who took it, especially what time it was taken, because as we pointed out in the reply, after the fact photographs cannot be used as evidence of what the scene looked like at the time of the accident, especially when you have first responders appear on a scene, because I promise you this, that when first responders arrive, they clear out everything that might be possibly in the way in order to get and do the work they need to do. But so the DPS fatality report, which is attached as Exhibit F and referenced in Mr. Smith's letter, and the photos of the crash site, neither of them have been authenticated, even as public records. And again, inauthentic, unattested records cannot be competent summary judgment evidence. I'm not attacking the crash report that's attached, because it actually contains information that helps to explain my case. But as far as those exhibits and the references in the Smith report, that's not competent summary judgment evidence either, without some kind of authentication, like an affidavit from a custodian of records for the fatality report and the investigation, and then an affidavit from somebody as to who took the photos, when they were taken, what they depict, all of that. That is required to be in summary judgment evidence in order for it to be considered and for it to create a fact issue. So if you take all of those things together, the Smith letter, the photographs, the investigative report, those cannot be used in this case, and there is no evidence after that. There's nothing that's competent summary judgment evidence that supports even a mere scintilla of evidence in this case.
Mr. Kimball, can I just, for my own clarity, can you tell me exactly what exhibits? I know you mentioned something about the crash report, but I want to make sure I understand what exhibits you are objecting to in plaintiff's response.
Thank you, Your Honor. Exhibit B is the John Smith letter. And it's, like I said, it's just a letter by itself. Exhibit F, which is what's called a DPS fatality report and inter-office memoranda. And that contains, I guess, investigation about the scene and the deaths. And Exhibit G, which is a slew of photographs of who knows when, how many hours after this accident took place. I can tell you that it's broad sunlight at that point, and the accident happened when it was dark. And so it's got to be hours after this accident took place that those photos were taken. But I have no idea how many hours and what has been changed in the scene. They're not authenticated. So those are the three exhibits that we've asked to strike.
Okay.
The other ones are our own discovery responses and don't really, there's really no fact contained in there. So we've argued in the alternative in the reply, say all of that gets in. Say the court is inclined to say, oh, I'm going to consider this. If you look at the Smith report, and if you look at the very last conclusion of that report, and it's on page 10 of his report, while he throws out little side facts and things that they're trying to rely on as fact, as creating a fact issue, like it was dark at the time, or he throws in a footnote that he says that it may not have been marked correctly as a construction zone. His ultimate opinion, which he was willing to give in this case, and this is 7 months ago, is the sole cause of the collision was the careless actions of Mr. Oresti. This is after he's considered all of these facts that the plaintiffs, excuse me, my light just went off because I was sitting too still. All of these facts that the plaintiffs are claiming create a fact issue. Well, Mr. Smith considered them because they're in his report. And even considering those issues that the plaintiffs say create a question of fact, he was able to state that the sole cause of the collision was Mr. Oresti. And he even makes statements in there that Mr. Oresti was driving without headlights, that Mr. Oresti crossed over into the lane of traffic of Mr. Alonso because of his accident reconstruction. As we pointed out, soul does not have multiple meanings. Soul has one meaning only. That's what Black's Law Dictionary defines it as, and they define it in sole cause. Sole cause is no other cause. So an expert's report, while it's hearsay against a party, if it's not attested to, I can use it, though, affirmatively and offensively in this case because it's considered an admission by party opponent under the rules, because it has been adopted. The truth of it has been adopted by the plaintiffs because they've now used it to create a fact question. Well, this is an admission. The admission is, their position is, Mr. Oresti is the sole cause, not a cause, not some cause, not a proximate cause, but the only cause of this accident. And so that is inconsistent with the argument that they're making in the summary judgment response, and should be dispositive of their argument that my client had anything to do with this accident. And especially, again, considering the fact that all of these fact issues come from his own report and he had the opportunity to consider all of them. Now, I know there's a continuance request on file, but this report has been in their hands for 7 months. If there was a question as to whether our client had any fault in this accident, there was 7 months just from the date of this report for them to do adequate discovery to shore up Mr. Smith's report, to get those issues. And they didn't do that because the only time that they started looking for arguments against my client is when I had to file a no evidence summary judgment after this case has been on file for 3 years. And because I have to, because under the new rules, I'm coming up on a deadline when I'm required to file summary judgments, because now they have to be filed 90 days before trial. So I'm running up against my deadlines. I can't, I've got to do that. So if you were to consider the Smith report as competent summary judgment evidence, which it's not, it closes the door on their claims. They've got claims against Mr. Oresti's estate. That's what this evidence is for. That's what this expert was hired to do. He's not a Texas highway construction expert. If you look at his report, it's an accident reconstruction report. That has nothing to do with what my client did in this case. So that closes the door on it. We have other arguments as well. If you're going to consider all this evidence, again, where in the Smith report does it say anything, or where in their response does it say that there's something we were required to do under the traffic control plan, which has been in their hands for over 800 days? There's nothing in the response or in their evidence that says there's something that we were required to do in that contract that we didn't do at the scene. That is required for a no evidence summary judgment, because that's what the breach is. The breach is TxDOT said to put something at this scene and you didn't do it, and therefore this accident happened. So not only did they not show that there's something in the contract that we didn't do, and they used the Smith report to say, oh, it was dark, you were probably supposed to put lights up. Okay, show me in the traffic control plan where it says I had to put lights up and I didn't. And this is a no evidence motion, so I'm not putting forward evidence, but I can tell you that there is nothing in there that said we had to put lights up for the public in this remote, already unlit scene. This is way out in the, in the desert on the highway. There were no street lights where this happened, but there's certainly nothing that they've shown in the traffic control plan that we were required to do at this scene that we didn't do. And then the final and probably most important element, causation, they also have no evidence of that. They have to show that not only did we have to do something that we didn't, but something that we didn't do caused this accident. And that has not been shown in this case. In fact, the only evidence they've put forward that shows what caused this accident is Mr. Smith's statement that the sole cause was Mr. Oresti and his negligence. So even if you throw out the Smith report, there's nothing else that's been shown that my client did, that even a remote scintilla of evidence that showed my client did anything that actually caused this accident that happened between these two individuals and caused this unfortunate outcome that where both of them died. And so again, our reply sets forth all of these arguments. We have lots of case law that shows, again, that the photographs don't prove anything because you can't use an after the fact photo from a scene of an accident to show what the scene of the accident looked like at the time of the accident, because too much can happen between the accident and the photos after. The only way you are allowed to do that is if you have an affidavit that accompanies them, and this is the case law, that says, yes, at the time of the accident and at the time of the photographs, the scene is identical. They have to have some testimony from someone. And unfortunately, I know it's not fair, both witnesses to this accident died. There are no witnesses. Nobody was out there and knows exactly what happened. But those photographs cannot be attested to as to showing what the scene of the accident looked like when it actually happened. And then finally, we've shown that there's no evidence of gross negligence either. If there's no negligence, if there's no breach and there's no causation, which we've attacked and which we have proven they have no evidence of, there's no gross negligence either. We have submitted a proposed order on the evidence being stricken as well, Your Honor. The three exhibits that we've listed to you this morning and the reasons why they're incompetent summary judgment evidence. As far as the continuance motion is concerned, as I noted.
So hold on, that's the one thing that I was, and I just I may be missing it, but the motion, there is a new motion for continuance?
It's a motion to continue the summary judgment, not the trial date.
And it's included within the response.
The response, gotcha,
Yes.
gotcha.
Yeah,
When
so
you were saying motion for continuance, I was thinking motion for continuance of the trial, and I was starting to freak out a little bit. Okay.
Well,
I apologize.
Yeah, we've presented case law that said that if, a court that denied 561 days is an example of, that's not an abuse of discretion to deny a request for a continuance between the discovery deadline and when the continuance motion was requested. They've claimed, we have to depose 7 people and a corporate representative in order to respond to your summary judgment. We have very little time before trial, and there's nothing that says they couldn't have deposed those 7 people in the 843 days since we disclosed them. I shouldn't be required to scramble to get witnesses ready to respond to questions that their own expert has already answered by saying the sole cause was Mr. Oresti, or a corporate representative. I shouldn't have to be the one to do all of that work so that they can respond to a motion that I had to file as my deadline was getting close because trial is impending. There's nothing that the requirement is, not only does it have to be not a long period of time since discovery was available to them, but they have to show that due diligence was undertaken in order to get that discovery. I don't have a single request for these depots until this response was filed last week. No letters requesting a corporate representative deposition at any point in time since we've appeared in this case. No request for any depots from my clients for that matter. And there certainly weren't any requested up to the point of when Mr. Smith was able to draft this report, nor was there a request in the 7 months since he drafted the report up to today. And so if they truly believe that F&F had some liability in this case, they had ample amount of time to develop that before I even moved for summary judgment. But I moved for it because I know they don't have any evidence. Even without seeing the Smith report, I've known they have no evidence. I didn't attach it to my summary judgment, but I did serve discovery to them on this, saying, what's your theories? And every single answer was, we'll supplement. Every single answer was, we'll supplement. So I never got any supplement to that discovery clearly asking, what are your theories? Up to the point of when I filed the summary judgment. So I shouldn't be required to start my defense anew after my client's been in the case 3 years. It's been long enough. They've had their chance to develop it. They got an expert. Their own expert told them, no, it's not F&F. It's Aresti. And they have to stand on that. Because now what they want to do is they want to go in and change their own experts' opinions. Feed him new info and say, hey, find anything against F&F, please. They had their chance to do that, and they didn't. My client shouldn't be in this case anymore. I respectfully request that the no evidence summary judgment be granted also against the Alonzo plaintiffs, and that the objections to the evidence be sustained as well.
Right. Thank you, Mr. Kimball.
Thank you, Your Honor.
The way I assumed it was you responding, but
Me, Your Honor? I'm sorry, I just didn't hear you.
yeah, no, I was
Yes.
assuming I assumed it was you responding since you filed the response. And I can tell you in terms of the reply, that pleading I had not reviewed, Mr. Kimball. So
I would request the court review it because I would even have said I would take the case on submission. The reply sets out everything that I need to say.
Thank you. All right, Mr. Zube.
Thanks, Your Honor. As the court knows, I mean, the collision occurred on July 24th, 2021 at 4:27 in the morning. And as Mr. Kimball pointed out, both of the drivers involved in the collision they died on the scene. And it occurred in a stretch of highway where F&F, according to its own discovery responses to which there is no objection, admitted that it is an F&F, was a TxDOT contractor, that it was performing work along Highway 302 between June and August 2021, and that it covered a certain mileage of distance, and that distance covered the crash site. They did also identify 6 employees with substantial involvement in traffic control at the project, and none of those witnesses have yet been deposed. I will walk through just briefly the evidence on each of the elements challenged in the no evidence motion, and then respond to a number of the points that were made by Mr. Kimball. The evidence of breach, we have that the admissions from F&F regarding its activities at the site during the time period when the collision occurred, and we have I believe competent summary judgment evidence we would submit in Smith's report, which indicates that the westbound lane was closed, the traffic had been diverted onto the eastbound lane and shoulder, and that evidence is independently corroborated by the Texas Peace Officer's crash report. And he indicates that there's photos that show that the construction zone may not have been properly marked. This is a piece of potential of some competent summary judgment evidence. It's more than a mere scintilla, as the court is aware of the standard of breach. I would also point out at this point a few things in response to Mr. Kimball's argument. One is that although the photographs that are taken after the fact, there's mention of case law that says that type of photography can't be considered. One of those cases is, I think, the city of Houston versus Crook, which is a Texarkana Court of Appeals decision. That decision involves the placement of a manhole cover. And there was conflicting evidence about where that manhole cover, I mean, just whether it was on the hole or whether it wasn't. That kind of situation is just a lot different than the kind of situation that we have here, where there are signage and lighting questions, and the photographs that we submitted weren't necessarily taken after the collision, but the vehicles that were involved in the collision can be seen, and the stretch of highway resembles what the highway that we know of as the collision site appeared to look like. I mean, the authentication requirement is simply that the pardon, I was going to read the exact language, and I seem to have lost it. That it basically that the proponent offers enough information for the court or the viewer to be satisfied that it is what the proponent says that it is. And in this circumstance, I believe that that requirement is met. It also represents to the court that there are DWQ responses from law enforcement officials that show the same images, essentially. And another thing about that I would point out is that Mr. Kimball and FNF, I should say, have kind of done this interesting thing with the no evidence motion, where they're filing it as a no evidence motion, but they're criticizing the lack of evidence of departure from the traffic control plan, which I think we've submitted sufficient evidence to show that without any kind of lighting or signage or marking, that there was an issue with the safety at the site. But the question about whether it complied with the TCP that's an affirmative defense, and there's plenty of case law that's cited in our response that references that, and that is FNF's burden to prove if they're going to prove it. So to kind of file a no evidence motion and say, well, there's no evidence of our affirmative defense having been not disproven, really flips the burden on its head. And one of the cases, for instance, on that, and let me pardon me if you bear with me for just one moment, Your Honor.
Mhm.
Yes, is the Supreme Court of Texas's recent decision, December 12, 2025, 726 Southwest 3rd 201, and Third Coast Services LLC versus Castaneda. And there are a number of other cases that I think are cited in our brief and probably in this decision that reaffirm the fact that the Chapter 97 defense is an affirmative defense. I'll move on next to causation. I would point the court to the summary judgment standard and what's going to happen at trial, which is that FNF does not need to be the sole cause attributable for the collision. It's enough that it is a contributing proximate cause. And I would want to address the point about Mr. Smith's sole cause conclusion. As Mr. Kimball himself pointed out, that report is kind of needs to be seen in the context of one of the central disputes in the case, which is about the fact of who crossed over the line and was improperly kind of out of their lane, and in the moments leading up to the collision immediately caused the kind of impact. Attributing that solely to Mr. Oresti shouldn't be misconstrued as a conclusion that no other person ever involved at the crash site could have had any role to play in the collision. And as acknowledged already, I mean, other notes in the report indicate that Mr. Smith did find fault with other parties who were at the site. I would point the court to the decision in J.D. Abrams versus McIver, That's a Texas Court of Appeals, Houston First District decision, holding that a construction company's negligence in setting up a construction zone was an approximate cause of a highway collision, even though a driver was also negligent. I think that case has a lot of parallels with this one, and along with the court's review of FNF's reply, I would ask the court to review that decision. And finally, I would just say that the continuance, is asserted in the alternative to outright denial. We believe outright denial is appropriate in these circumstances. But in the event that it's not, a brief continuance, even to depose one or two of FNF's employees who were identified as witnesses at the scene. I know that there's some mention of the delay. I think that the court is aware from earlier in the case that, and as can be seen on this Zoom call alone, there are a lot of people involved in the case, a lot of schedules to coordinate. And I also would note that we've had, I think at both of the plaintiffs' firms, significant change in the trial leads that I've had at Zell and Associates. We've had the departure of the trial lead on this case who was with it from the beginning. And I would just ask for not a continuance of the trial date. And I understand Mr. Kimball's concerns about the new rule and the scheduling. And just to be clear, this motion, I understand that the 90-day deadline applies in the case. This motion is not subject to that rule strictly in the sense that it was filed before the rule went into effect. So a continuance is possible on the hearing here, as long as it otherwise complies with the rule, I understand. But
so help me on that one, Mr. Zubay. You're saying that my deadline to rule on the motion for summary judgment doesn't apply to the one filed on February 12th? Is that what you're saying?
Well, I think that there are deadlines going both forward and backward from the trial date. And the rule says that the deadlines to rule on it and to be heard that rule does not apply to cases filed before March 1st, I believe, of this year. In this case, the motion was filed in February. And it does specify that it applies to motions filed March 1st or after. So I think any deadline that comes back from the trial date, I'm not disputing that would still apply to Mr. Kimball, but just in terms of the court's ability to continue this hearing, I don't think that anything in the new rule prohibits the court from doing that. I just wanted to make that clear.
Gotcha. Okay.
And I'm happy to answer any other questions, but otherwise I would rest on our briefs, Your Honor.
Your Honor, I have a very brief response, if I could.
Oh, yes.
Yes, Your Honor. And after Mr. Kimball responds, we would like the chance to just kind of clarify our position.
Okay. All right.
Okay.
Go ahead.
So I want to point out the argument was made that somehow I moved for a summary judgment on an affirmative defense. My motion made, in fact, expressly clear I was not doing that. If the court, I don't know if the court has our motion in front of it.
Yes, sir.
On page 5 of our summary judgment. What I'm talking about there is, look, you got to tell me what I did wrong under the traffic control plan as part of this motion. The reason that's important for you to even tell us what we did wrong, which they've never done, is because even if this goes forward, I have a statutory immunity defense available to me that says Texas contractors who are working for the state, heavy highway contractors, if they're in substantial compliance with the contract, which is the traffic control plan, we have absolute immunity, just like the state does. And I'm saying, and what I say in the paragraph where I cite that, I said the last sentence made clear, we're not even there yet. Okay, so I'm not moving, I didn't move on that statutory immunity in this motion, because I have no idea when I filed this motion what their theory was. Because as I mentioned, their discovery responses said nothing. I actually addressed the traffic control plan because it's in their petition. I didn't just bring it up as evidence to say this gets me off the hook. They're the ones in their petition who said you violated the traffic control plan. It's there in their petition. And I said, there's no evidence that we did. Show it to me. And they still haven't, even after the argument today. They're saying, oh, there's questions about lighting and there's questions about signage. That is in the traffic control plan. That says exactly what signage and lighting is required to be at where this accident happened. And at the time of summary judgment, they were to come forward with what was supposed to be there that wasn't. It's that simple. And if they had an expert like Mr. Smith, who I guess they're saying is qualified to testify about this stuff, which I don't know because we don't have a CV from him to know if he's even qualified to testify about heavy highway construction under a TxDOT contract. I certainly haven't seen that. But even if he had his own questions about it, he could have reviewed the traffic control plan and said, here's what they were supposed to do, and this is what they didn't. There's your fact question. And I would have said, thank you very much. There is a fact question here. And then I would move for summary judgment under statutory immunity because I promise you there is nothing. But so that is my response to that. We haven't moved on the affirmative defense. I know what a no evidence summary judgment is. It does and what it does not do. And so the last thing I will say is the statement in the footnote that they're referencing that says it may not have been marked properly. Okay, and they've clung on to that statement as, oh, see, look, that's a construction defect. That's what gets us over the hump. The summary judgment evidence in a no evidence summary judgment, the rules and the case law literally say it has to be more than may. It can't be speculative. It has to be clear and distinct and based on personal knowledge, or at least based on all of the facts and circumstances and stated clearly. Saying it may not have been properly marked is speculation. That in fact, it's on its face, it's speculative because it says it's may. They could have asked him, hey, you need to clear that up and say why it was improperly marked. And they didn't do that, and he didn't do that. And that is not a fact. That is not a scintilla of evidence to beat a no evidence summary judgment. So I would join Mr. Zubey in requesting the court to read everything that we've submitted. I don't know whether or not the rule applies or not on that deadline to rule. I thought it applied going forward after 2026. That was my understanding, but maybe I'm wrong. I do know this, Your Honor, we have a trial date in August. And now is not the time for continuances. Now is the time for the court to narrow the issues for trial. And I believe that we have narrowed my client out of this case. And again, I will request the court review our reply before it makes its consideration.
So just going back to that deadline, because yes, I think as I understand the 90-day deadline for courts to rule, I believe took effect in December. I'm just going over some of the clarifying communications we've had just amongst us here in the courthouse on that. And there were some additional I guess tweaks to all these different rules that are effective March 1st, but I understood that 90-day deadline for the courts to be in effect as of December last year. So yeah, it doesn't change with the new March 1st changes. It did not change the 90-day deadline that the court has to consider the motion.
Your Honor, if I may, I'm looking for what I'm fairly certain.
For what it's worth, my understanding was they take effect in March of this year.
Right.
Meaning going forward. they are in effect. But
So, okay, let me just hear, I don't want to sidetrack us on that. I'll look at that. Let me just hear what else plaintiffs have on the motion, and I believe Mr. Evans wanted to chime in.
Yes, Your Honor, and thank you. To kind of
I'm
clarify,
sorry, point of order, did I?
um,
Is Mr. Evans is also for the plaintiffs? I'm sorry, I wasn't sure.
he represents Ms. Guzman.
yeah, well, we're here on behalf of Claudia Guzman, the estate of Gilberto Aresti, and I understand that there's some claims that he had against F&F. And to clarify, Your Honor, we didn't want to take a position on the motion for summary judgment. We understand that the plaintiffs filed a response to the motion for summary judgment with evidence, and we wanted the court to decide on whether or not that evidence is sufficient because Ms. Guzman's claims are based in large part on the same facts. And so I know that Mr. Kimball said that the language of the rule says we have to file a response or else we concede our claims. That's not what the rule says. The rule says that there has to be evidence submitted in response to the motion, otherwise it must be granted, which is important because this is a motion for summary judgment against all the defendants. And a lot of these claims, the Alonzo plaintiffs as well as Ms. Guzman's claims are based on the same facts. And so it's our position, Your Honor, that if the court finds there's sufficient evidence for the Alonzo plaintiffs, then there's sufficient evidence for all the plaintiffs, for all the claims against F&F, because it would be improper to simultaneously grant and deny two separate claims based on the same facts at summary judgment. It would also be improper to submit it on a jury charge where some of the claims against F&F are going back to the jury, but some of the other ones based on the same facts aren't, that it would be confusing at that stage. And so we wanted to stand back and kind of let the court decide on the evidence submitted and whether or not that's sufficient. But if the court finds that there is sufficient evidence for some of the plaintiffs, it's our position that there's sufficient evidence for all of them. And that it would be improper to submit some of the claims, but not others to the jury charge when they're based on the same facts.
I really must respond to this, Your Honor.
I thought you might.
Well, first of all, if they wanted to join in the Alonzo summary judgment, it was simply a matter of filing within the deadline required to, under the rules, a joinder in their response, and simply say we join in their response and incorporate by reference all the arguments therein. Still would be just as infirm as the Alonzo plaintiffs, but they did not do that. And the rule is that everyone who's been moved against is required to file a response. You don't get to just sit back and do nothing and say, well, I'm just going to piggyback after the fact on whatever someone files. Now, this is outside of what's in the filing. But I will note for the record that I'd had a discussion with Mr. Leyva before the deadline for responses that is completely contrary to what Mr. Evans is now doing today. And it specifically involved my client not seeking costs against Ms. Guzman should the motion be granted for no response being filed. And so for Mr. Evans, who I assume has not spoken to Mr. Leyva before today, to now come in and ambush my client by saying, oh, never mind, we're now jumping on the Alonzo response and we think that the summary judgment should be denied against us. Unfortunately, it's my fault for not getting any sort of agreement under, as a Rule 11. That's on me. But it certainly is not it's not what I was prepared to discuss today, and it certainly feels like an ambush. But I'll stand on my response, and I'll also stand on my assertion that a party that does not respond to a summary judgment that has been directly brought against them, they don't file a response as the rule requires, it must be granted on a no evidence summary judgment.
May I very briefly respond to that, Your Honor?
Yeah, okay.
Your Honor, we're not trying to ambush or do anything improper. Our position is just that if there's some summary judgment evidence for some claims arising out of the same facts, then there's sufficient evidence for all the claims. And so that's all I had to say. And we'll stand back and let the court decide on the parties' responsive pleadings.
All right. Mr. Zubay, did you have something else? I'm sorry. I heard multiple voices and I think I muted you
I
when.
apologize, Your Honor. I
Oh,
think
no,
I
that's
was
okay.
confused. Thank you. But I had nothing further really.
Okay. All righty. Well, I'm tempted to ask Ms. Dominguez why she was shaking her head, but I don't know if I want to ask any more questions.
I'm sorry to do that, Judge. It's just that
That's okay.
I heard Mr. Evans say that he represents the estate, and I just wanted it to be clear to the court that Mr. Evans represents Ms. Guzman. The only representative of the estate is myself. I'm sorry to have made that obvious to you.
Oh,
And to
no worries. No worries. Okay. All right. So I have some work to do. And I am going to well, you're still asking for a continuance, right, Mr. Zubay?
In the alternative to outright denial, yes, Your Honor, we are asking for a continuance.
So I'm going to give myself about 30 days, but I need to look at your request for continuance, and I'll do that sooner than later. Okay. But this is going to be set for a judge's conference in 30 days. So yes, I only had reviewed the actual motion response, the reply that was filed yesterday, Mr. Kimball. I had not reviewed it, so yes, I'm going to do that. But you'll have something on the continuance well before the 30 days. Okay.
Thank you, Your Honor.
Thank you, Your Honor.
Time. Is that all we were scheduled for today? Yes? Okay, I just want to make sure I'm not missing something. Thank you, everyone. If you don't have anything else, then you are excused. And I think I need to give, I know there's several folks waiting, but I think I need to give Walter a couple minutes break here, so we'll take a quick break.
Thank you, Your Honor.
Thank you, Your Honor.
Have a good day, guys. Bye-bye.
You too.
Mr. Pai?
Yes, good morning.
Hi, what case are you here for?
1 second. Let me pull that up real quick. Something just disappeared. This is Wells Fargo versus Lucia Vasquez, Your Honor.
And then the bailiff. Ms. Vasquez? Okay.
Yes.
Great.
Yeah, and
All right.
we were trying to see if we can get a continuance to resolve that.
The judge will be on shortly. We're taking a break. So if you just hang around.
Okay.
Wells Fargo versus Lucia Vasquez, you said, right?
Yes, sir.
Okay. Thank you.
Yes, absolutely.
Mr. Nanez, that
Yes, ma'am.
Mr. Huerta's case, is that on the docket somewhere?
It is not. I was just about to talk to him about it. I was bringing up the case.
What is it
I
set
sent
for?
you.
Good morning, Your Honor. I apologize. I believe I was here for at least I had it on my calendar. I apologize for a pretrial. But Your Honor, I don't see opposing counsel, and we have reached a resolution. I do have the signed release that I'm sending in, Judge, and I can file a non-suit today.
336.
It's set for next week, Judge.
Oh, forgive me, Your Honor. I must have read my calendar ahead of time.
Let me just double check.
But either way, Judge, I'll have the non-suit and the release, or at least the release sent in with the company non-suit.
Check on docket culture. Yeah. Okay. Well, so if we receive it, we don't have to see you, I guess. But if not, we'll see you next week. Sorry for
No,
that.
I'll get it done, Judge. Thank you.
Bye Bye-bye.
May I excuse your honor?
Yes, sir. Have a good day.
I also sent him a chat earlier, Judge, that he was scheduled till next week.
Yeah, okay.
Yeah. Hi, Mr. Hall. What's your
Yes.
cause number, sir?
Let me pull that up. 2025 DCV 2836.
Okay, I left a couple of messages there with Miss Lobes. No one's answering. Thank you very much.
All righty. So I saw Mr. Perez. I don't know if he's still here.
No, Judge, I give him a call and let him know that there was a motion to continue in the case.
On 3040? Ah, okay, Mr. Rago. And were
Yes,
we
ma'am.
just going to the next setting on that one?
Yes, ma'am.
Okay, cool. Yeah, I saw him waiting there for a minute. But I see Mr. Hall. Mr. Hall, do you have, oh, it's only 2836. I have it for a status and a default. Let me see.
Correct.
Let me get to your case really quickly. Okay. did we get notice out to defendants?
That's what I'm checking on because I didn't see notice of hearings, and that was my concern going into this today. I was like, I don't see that we sent the notice of today's hearing out, so I was having my folks check on it.
Okay, so that sounds like a reset on the default. We can consider that our status since it was set for both today. Yeah, just make sure that for the next setting, which I'm happy to just give you today because these are pretty straightforward.
Yeah.
We'll do April 8th
That'll work.
at 10 a.m. 4/8 at 10 a.m. our time, right? I don't know if you're out of town, but get the notice out and then we'll go forward on the default, okay?
All right, and it'll be the same Zoom
Same,
info as
yeah,
today.
the link is the same. Yes, sir.
Okay. All right,
Thank
I'll
you
get
for your
that done.
time. Thank
All
you
right,
for your
thank you,
patience.
Judge.
Bye-bye.
Yep, bye.
And then I know Mr. Nicky was also, oh, there he is, Mr. Nicky. Good morning.
Good morning, Judge. How are you?
You ready on your default?
I am, Your Honor.
Okay, let's get going. I know we had so many of these other hearings pending. A ver. Calling cause number 2025 DCV 4135, Contractors Barricade Service versus Spartan Energy Services. May I have announcements, please?
Good morning, Your Honor. Stephen H. Nicky on behalf of the Plaintiff Contractors Barricade Services, Inc., doing business as Apache Barricade and Sign.
Oh, okay. Hold on. Are we still going forward? I see a non-suit. Oh, this is just
No,
one. Gotcha.
Yeah, we non-suited. Mr. Hereford passed away, so we just got him out of the case.
Okay.
And we've only been able to serve Spartan. Mr. Campbell has been evading service, and we still have not been able to serve him yet.
Okay. So let me go back a little bit. It looks like our order setting hearing, let me look at it. The default hearing was February 13th, so that's sufficient time for my purposes. Yes, it was set for default. Let me just ask you, Mr. Nicky, did we attempt to send notice of the default hearing to
the LLC? Just yes, ma'am, and it was returned to me, just saying return to sender. Didn't say why.
Okay. All right, you may proceed. Got it.
Thank you. Your Honor, this is a case that was filed on last year. I think it was 9/10 of 25. We filed suit for breach of contract, quantum merit suit on sworn account, money hadn't received, Trust Fund Act, Prompt Payment Act, and attorney's fees. The suit on account has complied with Rule 185. There's an affidavit on file attached to my petition with a statement of account. In regards to the Prompt Payment Act, we're seeking interest pursuant to that act at the rate of 18% per annum on the balance that's due. Since the defendant has been served and failed to file an answer and doesn't want to respond to my correspondence, we would ask the court to enter into a default judgment against Spartan for the principal balance owed of $125,497.83. The prejudgment interest calculated at the 18% per annum pursuant to Chapter 28 comes to $30,119.48. We've incurred attorney's fees of $4,596.25. An attorney's fees affidavit has been filed, and court cost of $630. So we're seeking a default judgment against Spartan Energy Services for the barricade services my client provided to them for multiple projects throughout El Paso for the total sum of $160,843.56.
So I am seeing on your motion for partial default, attached is the only exhibits attached refer to the attorney's fees, correct?
The attorney's fees, and then we incorporated the exhibits attached to the plaintiff's petition. So attached to the plaintiff's petition would be the sworn account affidavit and the statement of account.
Let me just go back and review that.
and also a copy of the contract, which is Exhibit A. Exhibit B is a sworn account affidavit signed by my client, Ms. Gamboa. And then attached to her affidavit is the statements showing the principal amount due.
Understood. Okay. All right. So the court will take judicial notice of all the documents in the court's file, including the exhibits attached to the motion for partial default. Will grant your request. You may have provided it. I don't know that I've gone through all the emails this morning. If you have the proposed order, please just send it on over and the court will sign off on it. All right.
Yes, ma'am. I think it's been sent twice to Myrna, so you should have it.
So yeah, and Marissa, let me just check. Is Myrna retired?
Oh, did she really? Oh, well, then
Did.
maybe you didn't get it. Who should I send it to, Judge?
So it goes to Marissa Nieto is the new court coordinator, and it is ma.nieto.
M.A. dot Neto, N-E-T-O?
Nieto, N-I-E-T-O.
Oh, okay.
Mhm.
I
I think they
will,
had some process where stuff was automatically going to her, but I'm not so sure. I don't know how much I trust it anymore.
okay. No,
So
I
it's in the
appreciate
chat.
it.
It's in the chat, Mr. Nikki, and I'll look for it. I may have it. Other than that, we're good to go. Thank you very much for your time.
Thank you, Judge. May I be
Have a good day.
excused?
You may. Have a good day. All right, Miss Zavala and Miss Apia Boateng. Ma'am, can you turn on your camera, please? And I thought I heard someone talking about a reset.
Yes, good morning, Your Honor. How are you?
I'm well. Calling cause number 2025 DCV 4833, Wells Fargo Bank versus Lucia V. Vasquez. May I have announcements, please?
Monica Zavala here on behalf of the plaintiff, Wells Fargo.
En Rhode Apia Watson present for the defendant, Lucia Vasquez, Your Honor.
Thank you for your patience today. We are set for a motion for summary judgment. Let's see. I have a motion filed on the 11th, a response filed on the 17th, and plaintiffs requested what? The hearing. Okay. So is there like some type of status I need to know about before we start talking summary judgment?
Well,
I don't, did you say a response to the motion for summary judgment was filed or one was filed?
I have an entry. Let me open it. Defendant's response to plaintiff's motion for summary judgment filed on the 17th of February.
I don't have a copy of that.
And Your Honor, we were trying to see if we can get it continued so we can try to work out a possible settlement if possible, like a 60-day continuance.
So it was
Before ruling on the summary judgment.
It was filed in February. Why was it not served on opposing counsel?
Should have been served. I mean, if it was e-filed, they definitely would get an copy of it.
Miss Duran, are you there? Yes. Or who am I talking to? Is it Serrano or Miss?
It's Ms. Duran.
Okay.
Currently e-file and EJC are both very short or slow on my end as well.
Yeah.
But
I don't see, well, no, this is a letter. Sorry.
as far as the response, it doesn't show any parties were selected to receive that filing.
So yeah, it was not, I mean, it might be indicated on the pleading, but it doesn't show that it was served. So we are going to reset this for 2 weeks.
Okay.
That's what we're doing for now. Miss Zavala, and so Miss Apia Boateng, you need to serve Miss Zavala with the response. All right? And we'll see where we are then. Miss Zavala, do you anything for me?
Can I get her email?
Yeah, Miss Zavala, go ahead.
May we get a date and a time, or will we just get a notification from the court?
So we're looking at the 25th, and I would say at 11 a.m.
March 25th at 11 a.m. Okay.
Okay. Alrighty. Okay.
Yes, Your Honor, I was just asking for her email if she wanted us to send her a copy.
So you know, you need to make sure that it is done. I mean, I'm fine if you're gonna email it to her, but when the pleading is filed, make sure you select service on opposing counsel. Okay?
Yes, I'm not sure what happened, but I'll make sure that that's sent to her.
Alrighty.
All right, thank you, Judge.
Mm-hmm. Miss, she didn't wait around for your email?
She probably has a copy of it with on all the pleadings, probably. But thank you, Your Honor. May I be excused?
You may have a good day.
Thank you.
Yeah, all right. That's everybody, brother.
Yes, ma'am.
Thank you very much.